Welcome to I Rest My Case, our new podcast series. I'm Dean Strang.
And I'm Jonathan Goldberg, KC. In each episode of I Rest My Case, we will discuss and dissect a famous legal case. We will pull back the curtain on courtroom trials and indeed tactics and advocacy, and we'll try to shed some light on what goes on behind the scenes, on the how, not just the why, of the criminal justice system. We'll be doing it from our two perspectives, that of the American trial lawyer, who is Dean, and that of the English trial lawyer, who is me.
Today we turn to a United States case that happened in the state of Minnesota, the upper Great Lakes region of the United States, and became famous worldwide, or infamous worldwide. This was the death of George Floyd at the hands of Minnesota police officer Derek Chauvin, observed and uninterrupted by three other uniformed Minneapolis police officers.
On the 25th of May 2020, an unfortunate man called George Floyd, who was a black man, very importantly, entered a convenience store and he tried to buy some cigarettes with a counterfeit $20 bill. And this was seen straight away by the shopkeeper. The police were called, and George Floyd, who was a 46-year-old Texan originally, he had a criminal record. He'd done 5 years for robbery, perhaps 10 years earlier, and he was a drug addict. And indeed, they found that there was fentanyl and methamphetamine in his system when he was eventually given an autopsy. He tried to drive off in his car. Two police officers arrived at first, not Mr. Chauvin, and they tried to get him to exit his car. He was uncooperative and resisting coming out of the car. They dragged him out. They put him on the floor. And at some point, Chauvin arrived with another colleague. And not long afterwards, Chauvin, trying to arrest and handcuff George Floyd, put his knee on his neck. And that knee stayed there, very firmly planted on George Floyd's neck for 9 minutes and 29 seconds. And this statistic of 9:29, one can say, became the leitmotif for the prosecution in everything that followed. So there's no question there were many bystanders, there were many witnesses, and one of them, a 17-year-old witness, recorded the whole thing on video on her telephone. And so there was no question as to what had happened. It was captured on video from first to last. And although George Floyd was screaming really as best he could, at one point, "I'm dying," at another point, "I want my mother," at another point, "I can't breathe," the fact is Chauvin kept that knee on that neck the whole of the 9 minutes, 29 seconds, and bystanders were saying, "Leave him alone, take your foot off," all this sort of thing, and he was not responding. There is, in fairness, evidence that the crowd were getting very aggressive and the crowd was growing and becoming perhaps threatening. And at some point, Chauvin pulled out a can of mace and threatened to mace the bystanders. Anyway, at some point, he took the knee off the neck. Paramedics arrived, and by now, George Floyd had passed into unconsciousness. And they tried to revive him at hospital, but he died. There was some controversy as to the cause of death because the prosecution were, of course, saying it's the knee on the neck that stopped him breathing, simple as that. And moreover, that this was a position that police officers were trained to know was inherently dangerous, and they shouldn't use it except in the most extreme circumstances where they were themselves being threatened. And of course, it could hardly be argued that these were extremely dangerous circumstances for Chauvin, because he had 4 heavily armed policemen in all. By this time, George Floyd was in handcuffs behind his back. So pretty much on any sensible view, he overreacted massively, putting it very kindly. But for the defense, it was argued at trial that there were underlying conditions which caused Floyd's death rather than the knee on the neck. It was said, firstly, that the drugs he had undoubtedly ingested may have led to heart failure. It was said that he had congenital heart problems that may have caused his death, where for anyone else, they wouldn't have died, and the police would have been entitled to effect the arrest in those circumstances in that way without acting unreasonably. So these were the controversies at trial.
George Floyd was a black man. Derek Chauvin is a white man. The other officers at the scene, some of them were white and some of them not white. But there was an undeniable racial dynamic to this confrontation that resulted in George Floyd's death. For listeners who are not from the United States, there's some context here that I think is important. One, the Minneapolis Police Department at least has had a long-standing reputation of repressive approaches to that city's black community. How well that's deserved, all subject of fair debate, I'm sure, but there was that long-standing reputation and undeniable, I think, tension between segments of the Minneapolis community and its police department. Another point that, again, American listeners may remember and know, but those outside the United States may not, is that Monday, May 25, 2020, the day that Derek Chauvin caused George Floyd's death, was a holiday, a national holiday in the United States. It's called Memorial Day. It began shortly after the Civil War as Decoration Day and has evolved over the time since the Civil War into the day we acknowledge the service and sacrifice of members of the United States Armed Forces, especially those who've died in the various wars in which this country has engaged. So people were off work, and it's the traditional beginning of summer in the United States. People would have gone back to work, many of them the following day, Tuesday, May 26, but the summer starts and there is a slowing of pace at some level around Memorial Day. So when the video from the young woman was released, it went viral the next day, and the country, indeed the world, saw in real time the entirely preventable and avoidable death of George Floyd. Here we have someone whom well may have been seen at some level by members of the Minneapolis Police Department as an enemy combatant, as an uncooperative member of the public in the us-them way that police officers often look at the public they police, but who was not mortally wounded until he encountered Derek Chauvin and the other officers at the scene. The charges followed by the end of the week, as I recall, but drama ensued with that, didn't it, Jonathan?
Yes, drama ensued because there were two versions of the early charges. One, the first version was, one can say, pro-police, and then a few days later came the second version that was much more fairly balanced, and one can say perhaps fairer to the deceased.
And at some point, the autopsy report was changed, undoubtedly if not at the request of the prosecution, certainly to the benefit of the prosecution. And at least in the United States, county medical examiners, the people who conduct an autopsy on a death that occurs in public, are employed by the same government that employs the prosecutors and work closely with municipal police departments like the Minneapolis Police Department and with the county prosecutors. At the end, by the time he stood trial less than a year later, Derek Chauvin, who was charged with killing one man, and indeed only George Floyd died or was injured here, Derek Chauvin faced 3 different homicide counts for the death of the same man in state court. He also had looming a separate federal charge on the horizon. And this may seem strange to listeners in Great Britain, but recall that America has a federalist system of government, meaning all Americans live under two sovereigns, one, the federal government, and two, the state government in whichever state they reside. And below the state government, as subsidiary governments, local governments who draw their power from state law. So there really is a system of dual sovereignty in the United States. And our criminal law, rightly or wrongly, but clearly all the same, allows both sovereigns to take a shot at a criminal defendant. Each may charge that defendant if it has an applicable criminal statute that at least allegedly has been violated. And there is no double jeopardy concern, so says the United States Supreme Court, and has since at least 1959.
Dean, this raises an aspect that troubles me as an outsider. And I think I'm going to be saying to you at the end of the day that I think the British courts would have handled this case better, important and serious case as it was, because to me as an outsider, it became something of a three-ring circus. And I'm going to try to justify that criticism if I may. But can I begin with the question of pretrial publicity? Because I noticed in this case that the lawyers on both sides were busy giving interviews on the court steps, asserting either the guilt or innocence of their respective clients. I noticed the prosecutor, who was specially chosen and made a big point of the fact he was acting for free because he was a very successful commercial attorney normally. And he said that he was acting without fee because he was so outraged what had happened to a fellow black man, that he had members of his own family who had been persecuted and even in the past lynched by the police. And he was saying all this in interview. The State Attorney General, Keith Ellison, was saying he would never have taken the case on if he weren't sure of Chauvin's guilt. Now, if this had been England, I'm in no doubt these lawyers would quite literally have been disbarred and would have been found guilty of contempt of court by the judge if they had prejudiced a forthcoming trial, however guilty or innocent the man was. Doesn't matter. He of course is entitled to a fair and unbiased trial under both systems, theoretically. But how can such statements be allowed, and how much are they allowed in your system? Because, as I say, in the system with which I've grown up, they would be very much frowned on.
You have pointed out a significant difference between the U.S. legal system in that respect and the British legal system. It is true that robust pretrial comment is not only tolerated but welcomed in the United States under the First Amendment to the U.S. Constitution. However, when that comment comes from lawyers, people admitted to the bar to practice law, there are some constraints on the lawyers. We are not to say something before trial where we reasonably should understand that it could prejudice a proceeding, that it could taint a jury pool or otherwise affect public opinion in a way that might prejudice the outcome one way or the other. Nonetheless, there's a real problem, in my view, here, because many of the speakers, at least initially, those who are first to the microphone in the U.S., are not lawyers. They are police officers. They are politicians. And even if they have, law degrees as politicians, which some do, not all, even if they have law degrees, they may not be admitted to the bar and may not be practicing law. So they are not constrained by these same rules of professional conduct that apply to lawyers. And this case is a great example. Some of the first people to speak were police leadership, the police chief, others in command positions in the Minneapolis Police Department. The mayor of Minneapolis was early to speak. The governor of Minnesota was fairly early to speak. And then you have hybrids like Keith Ellison, the Attorney General of Minnesota. He, of course, is a lawyer, admitted to practice, subject to the rules of professional conduct, but he's also an elected public official. And the reality in this country, at least my experience is that courts are really quite tolerant of those on the prosecution side and those who may be lawyers but hold elected office, making comments that a reasonable person could say that crosses a line. That is likely to prejudice a later fact finder, a judge, a jury, who will have to hear the case, and as you say, in theory, should be deciding it as a neutral, as a fair and impartial fact finder. Beyond that tendency to at least step over the line, you have the practical problem that the police, the prosecutors are the first, as I said, to get to a microphone. They get primacy in forming the public narrative. And the media in this country, especially the legacy media, but not only the legacy media, I think are very, very quick and compliant about propagating the narrative that a prosecutor, a police chief, a police department spokesman offer.
And it has to be said, doesn't it, Dean, that all the people who you've named all came out with comments that condemned Chauvin well in advance of his trial.
Oh, in eloquent terms. So then you have the defense lawyer who feels like a response is invited, and I have a job to do here to try to sweep back the tide, to try to offer a competing narrative, either of innocence or of mitigated guilt, often. If nothing else, a message to deliver to the public that they ought to withhold judgment until we actually hear the evidence at a trial. But the defense is coming along second, necessarily, doesn't have the advantage of primacy, and doesn't have the advantage of wearing a uniform or holding an elected office. So you do get into an unseemly contest in the United States in closely watched, closely followed trials. Now, Jonathan, it has to be said, doesn't it, that of the 20 million criminal cases filed in the United States every year, 11 million of which are traffic crimes, but of the 8 or 9 million misdemeanor and felony cases filed in United States courts every year, there are maybe 100 or 200 that get any real statewide attention, let alone nationwide media attention. So this is a problem at the edges. But in the cases in which it is a problem, it's a problem.
Because they will be the most important cases by definition.
Important in shaping national debate, important in shaping national attitudes about our police, about our court system, how the system operates. Absolutely.
Can I just give you an example from Great Britain of how seriously we would take this sort of thing and how we would simply not allow it, and there would be the most severe penalties? And the example I'd like to give you is a case in the early 90s, I believe it was. And I'm sure everyone has heard of Lord Denning, who was the great British judge of the 20th century. And Lord Denning was now retired. And an IRA terrorist was on trial, if memory serves, for a bombing. And his trial was ongoing. He did not choose to testify. And Lord Denning then made a public statement, I think it was during a lecture or something of that kind, and he made a public statement, not referring specifically to the case, but saying that he thought that anyone who didn't give evidence in his own defense had something to hide, and he thought the law ought to be changed whereby inferences of guilt could be brought against any man who in his own criminal trial did not take the witness stand. As an amusing footnote, Tony Blair later changed the English criminal law to be exactly that, by the way. However, this caused murders. And they went to the Court of Appeal when the man was eventually convicted and given an enormous sentence, in the decades measured by. And it went to the Court of Appeal. And what do you know, despite the enormous reverence with which Lord Denning was then and continues to be held by his brother judges, and rightly so, they quashed the conviction and the man went free because they said it was inevitable that the enormous press reporting of this statement by this revered judge would have become known to the jury.
Well, and the statement to my ears was outrageous. It attacks the presumption of innocence, and it sought directly to undermine the centuries-old privilege against self-incrimination that we inherited from England. That said, there's no question in the United States, I think Lord Dunning would not have caused that kind of change in outcome in a criminal case. We simply tolerate a lot of pretrial comment from all quarters in the press and otherwise that the United Kingdom would not. There's no question about that.
Is it something to do with the constitutional right to free speech?
Yes, the First Amendment, which includes a right to free speech and also includes freedom of the press. Obviously now in an electronic age understood to include all media, including social media. Prior restraints, as they're called, simply are not allowed other than in the rarest circumstances where national security is at stake, for example.
Well, can I take an example from this very case, Dean, in which I found what happened in the Chauvin case so different from anything I would have experience of? And the example I would choose is the newly appointed police chief of Minneapolis, in other words, Chauvin's direct boss, who within 24 hours of Chauvin's arrest came out with the most extraordinary statements, as they seemed to me, at a press conference, which undoubtedly accused him of being guilty of murder. So happens the police chief was a black man, and it so happens he eventually gave evidence, moreover, as a witness at the trial, in which he said that the form of restraint Chauvin had used was excessive and unauthorized and no excuse for it and so forth. So he was an important expert witness as well, which it seems to me makes his offense the greater to have prejudged the issue in the way he did. Now, what would have happened if that had happened in England? And I have to say, it simply never would. I can't think of a case remotely similar. But if it had happened in England, his feet would not have touched ground. He would have been hauled before the judge at the Old Bailey, let us say, and he would have been found guilty of contempt of court. He would have had to apologize abjectly, and I think it's actually very likely he would have got 3 months in the slammer in a case such as that and lost his job.
Here, no judge would view that as contempt of court, at least not in the legal sense on which a judge could act. And I think there's something more important or additional to say about that kind of thing from the police chief, for example. He was talking about and roundly excoriating, understandably at that point, roundly excoriating an officer who had 18 prior civilian complaints against him, who twice had shot people earlier. Now, one of those probably was a justified shooting and killing. The other, the person he shot, was armed as well. Both prior shooting incidents involved armed suspects. But he had shot 2 people earlier and had, as I say, 18 civilian complaints about excessive use of force. And that same police department, not necessarily on Chief Madaria's watch, I don't know how much was on his watch and how much not, but that same police department had dismissed 16 prior civilian complaints of excessive force against this officer and had at most reprimanded Derek Chauvin as to 2 of those prior complaints.
Will you forgive me if, as an old friend, I play the devil's advocate for a moment, because I saw what the defense said about that. They said that of the 18 complaints, 16 had been dismissed. They said of the shootings, he'd got medals for 3 of them for the very brave way he effected the arrests and disarmed armed suspects, because he wasn't shooting unarmed people. He was shooting people who were shooting at him and another officer. Now, it does seem to me that unless you were to go into the background of each and every one of these incidents, which of course no trial judge would allow in either your country or mine, because you can't have satellite litigation of that kind. Cases would go on forever, and they go on long enough as it is, as you and I well know. But wouldn't you agree with me that a police officer in America is a very dangerous occupation? Guns are being fired at him. He's having to fire guns in his own defense, much more so than in Great Britain, where the police are unarmed, as we all recognize. I've defended so many professional people, from doctors to police officers to accountants to solicitors. I think it's a very rare and lucky person in any profession who doesn't receive false complaints at some stage in their career. And particularly, I think it's difficult if you're a police officer, because you're in the front line against the kind of people, in general terms, who are prone to making false complaints.
Let's unpack that a little bit, Jonathan. And to be clear, let's start with this. As I understand the prior record, he had fired his weapon at two people previously, one of whom was shooting or preparing to shoot at police officers, not necessarily at Chauvin directly. That doesn't matter. He gets to fire in defense of officers or indeed civilians. And the other was an armed man, and so therefore could have used his firearm. Not disputing that. Those were two incidents. The 18 civilian complaints concerned other incidents of excessive force, 16 of which the police department itself dismissed, two of which the discipline rose no higher than a reprimand, literally a finger wagging, at Chauvin. And lest you think that the police department was right in its internal handling of those, one of those 16 civilian complaints formed the basis for the federal civil rights criminal charge to which Derek Chauvin eventually pled. He had kneeled on the neck of a prone 14-year-old boy, face down on the floor, and that boy too had said, "I can't breathe." But fortunately, that boy, that 14-year-old kid, survived. But that incident in 2017 resulted in exactly no discipline of Officer Chauvin or of the other Minneapolis Police Department officers who stood by idly watching him do it, exactly as 3 officers stood by here on May 25, 2020. Now, as to the danger of being a police officer, I'm not going to disagree. Look, in the United States, there are something over 400 million firearms in private hands. This is a country that is armed to the teeth in many households, no question about it. And our firearm violence rates, whether those are suicide or homicide or just injury by shooting, are higher than anywhere I know, okay? No question about that. Is policing dangerous? Of course it is, in part for that reason. However, I think bear in mind that when you look at the most dangerous jobs in America, policing comes in somewhere in the top 10, but not in the top 5. Farming is much more dangerous. And if we look at loss of limb, serious bodily injury, and death, just for example, okay? So there is no gainsaying that policing is a dangerous profession. It can be a terrifying profession, and it can be a noble profession at times. But we tend, I think, to mythologize the role of the police officer here, especially among communities who have little to fear from the police and don't tend to have the unpleasant interactions that over-policing can have, where a call for service from a citizen languishes for an hour or more, but a police-initiated encounter can become abusive and even violent very quickly. So I do think it's a complicated picture here. I meant only to make the point that some of these politicians were awfully late to the party in recognizing the problems with this particular police officer, and the police department itself had failed to self-correct. I bring up the prior shootings only because there is some evidence emerging, and I'm not a criminologist, I don't know all the studies, but there are some studies emerging that show pretty clearly, at least in, for example, the Los Angeles Police Department, the Chicago area, that show pretty clearly that by great disproportion, excessive uses of police force tend to be done by officers who have done it before. it tends to be a repeat phenomenon disproportionately, not exclusively, but disproportionately, it appears. Now, more study would be needed, but police departments are notoriously bad at keeping good statistics on use of force by officers. And I think one of the problems in any event with this perhaps propensity of those who've used excessive force before to do it again, one of the problems is that feeds into, oh, it's just a few rotten apples sort of narrative, and allows police departments and municipalities to avoid a more organizational and systemic review of the culture within the police department that may be feeding the excessive use of force on occasion as it is.
Well, I'm fascinated to hear, and I've learned something I really didn't know, that farming is a more dangerous occupation than policing. The farmer, at least, is not going to get complaints as a matter of daily routine from his sheep and his cows and his bulls and whoever else are causing him danger and accident. But of course, a police officer is.
Yeah, cows don't have opposable thumbs. They can't fill out a complaint.
Absolutely. Do you know, Dean, we had a situation in England, and it was about 10 years ago, and it didn't last very long for obvious reasons. And when criminal defendants who'd been convicted were going into prison, the first thing they were given was a form which had various questions on about their well-being and all the rest of it. But one of the later questions was literally phrased in this way: do you have any complaints against your barrister and solicitors? Well, of course, it's a rare defendant who's just been convicted and sent to prison that isn't going to have some complaint against his barrister and solicitor. Of course, this caused uproar, and I'm told the question is no longer there. Let me at least ask you this. Do you think policing improved in America as a result of the Chauvin case?
No. I think there may have been incremental progress here and there. There's no question that shining a light on what happened there caused a national conversation ongoing, but that's not a one-sided conversation. You know, there's substantial pushback, as you noted earlier, and just as you have a Black Lives Matter movement, which actually started years before George Floyd, you've had a Blue Lives Matter movement defending the police. So, as always, these things are fractious in the United States. I answer your question no, because I'm not convinced that any sustained effort to address the underlying problems within police departments, and indeed within our communities more broadly, has taken hold in any robust way. Now, that said, yes, you can point to specific improvements at the edges, I'm sure. Training on use of force, training on de-escalation, training on positional asphyxia, maybe greater enforcement of rules banning certain compliance techniques, like putting someone on their stomach, handcuffing them behind their back, and then putting your body weight on their thorax. So there, you know, at the edges, there may be, and I'm sure have been, specific improvements. I know there have been in Minneapolis and probably beyond Minneapolis. But has there been the sort of sustained self-examination and self-correction that Alexis de Tocqueville, you know, in the middle of the 19th century, gave America so much credit for its capacity to undertake? I don't think there has.
Can I then move to another contrast between my system and your system, and that's the question of jury selection. Let me tell you in just a few sentences how it works in Britain, because it's so much simpler, really. You take what you get. So when I was young, practicing in criminal law, for example, at the Old Bailey, or indeed any other Crown Court, you were allowed 7 challenges without having to give cause. Cause would be if it's your next door neighbor or your Auntie Bertha, then of course you can ask that that person be removed from the jury. You challenge them for cause. And that still exists. It's theoretical, it never happens. But without giving any reason at all, you could just get rid of 7 jurors as they came to the book to be sworn on their oaths. And we used to do it in no more scientific way than this. If they were readers of the Times newspaper that was sticking out of their pocket, we would challenge them in a case where we didn't want an intelligent jury. If they were readers of the Sun newspaper, we would let them stay. And of course, it could be vice versa. You might want an intelligent jury, perhaps in a fraud case, or indeed perhaps in a fraud case, you wouldn't want an intelligent jury. So you would do it with nothing more scientific than that. If they were wearing a suit and tie, you might want to keep them. Equally, you might want to challenge them. It was pretty absurd. And because each defendant in a multi-handed trial was allowed 7, if you had a trial with 10 defendants, and they were frequent at the Old Bailey in those days, you literally had 70 challenges, and it could take days to swear a jury. But you weren't allowed to ask them any questions. You weren't allowed to cross-examine them. Now, when I was getting a bit older, that was reduced to 3 peremptory challenges, and today we have none. So literally, you take the jury you're given and you do the best you can, and that's it. Would you like to describe briefly, perhaps for our listeners, how it works in America by contrast?
It's an impossible question, Jonathan, at least to answer briefly. I mean, bear in mind that we're talking about 50 different states with 50 different rules of procedure, therefore, plus the federal government and its federal courts that have their own process. But let me say generally, what you're describing to me as a challenge without cause, we call a peremptory challenge. We also have them here. They are still allowed, I think, in every state, but the number of peremptory challenges allowed varies dramatically from state to state, all right? 6 in one state, 4 in another, 10 if it's a multiple defendant trial, but they have to split them, and all over the place, all right? But the peremptory challenge does survive in the United States, I can say that, both in federal court and in all of the states' courts. The questioning of jurors varies dramatically. It may surprise you to know that in federal court, in most federal districts in this country, there is no lawyer questioning of the jurors allowed. Only the judge poses questions to the jury panel, and that's for the purpose of allowing the judge to decide, is there cause, as you described, to excuse a juror? Now, in the United States, we were talking earlier about pretrial publicity. If it's a closely watched, highly visible trial, you'll have cause to dismiss a number of potential jurors simply because they've already made up their mind based on the pretrial publicity with which they're familiar. In the vast majority of cases, which are utterly unknown to anybody outside the direct participants by the time they get to jury trial, you don't have that problem of, pretrial publicity requiring you to disqualify jurors for cause. In the state courts, often the lawyers are allowed to ask questions of prospective jurors, but how much latitude the lawyers get on both sides varies dramatically, not just from state to state, but from judge to judge within the state, because this is a matter left to judicial discretion. Each individual judge can decide what questions, how many questions, how long, what's out of bounds, what's not out of bounds. So when you step back, it's fair to say that we still have peremptory challenges, although limited in number, and that the picture on lawyer questioning jurors is very mixed because most trials occur in state courts. There is some lawyer questioning of prospective jurors that's ordinarily allowed.
Do you think this is fair? Is this really a trial by your peers when you are able to exert so much influence, relatively speaking, on the jury you're getting?
I don't know that I agree with your premise. The panel that's brought in is the universe of people you'll have. So if 35 are brought in, 12 of those 35 are going to wind up on your jury, unless something really goes askew, okay? Or a 40 or 25 or whatever it is. So you're not picking a jury, you're deselecting the people you least want on the jury. And just as if this trial were happening in the United Kingdom, we're often making gut calls on heuristics or sort of preposterous stereotypes and assumptions. What newspapers do they read? What bumper sticker do they have on their car? That kind of thing. You're making a very rough guess about whether it's worth expending a peremptory strike to remove this particular panel member. But you're not picking the 12 jurors you want. You're just getting rid of the 4 or 6 you least want based on the limited information you have. I brought up earlier the fact that Chauvin ended up with 3 homicide convictions for the same death and a 4th federal conviction for depriving someone of his civil rights by causing his death. He winds up effectively with 4 homicide convictions for killing a single person, giving the state prosecutors 3 bites at the same apple, and then the federal prosecutors coming along later with somebody who's already gotten 22 and a half years in prison. Does any of that seem strange to British eyes, or is that similar to what you'd see across the Atlantic?
Dean, it seems incredibly strange. I was going to ask you, didn't they really throw the book at this man, whatever you think of him, in an unfair way? Because there was this multiplicity of charges, and I can't see for myself at the moment what the federal breach of Floyd's civil rights trial added to this state trial, and they seem to have been pretty much the same sentence, roughly 22 and a half years. I think it might have been 21 for the federal charge. So what was the point of that second trial? And then I noticed, and really I couldn't believe my eyes, when I saw that they also brought income tax charges against Chauvin and his wife. They hadn't been paying their full amount of tax. They'd been fiddling their tax, I suppose. And those charges were brought as well. And then I saw they brought the old case, which you were mentioning, where he'd forcibly arrested the 14-year-old boy in 2017. Now, that would not have happened in Britain. The prosecution would have chosen their best charge or couple of charges. They would have abandoned the rest. If they didn't, the judge would have said, I'm not having this. The judge would have said, I'm not having a 5-month trial when we can do all this in a 1-month trial, and it will be the same penalty. Any good judge would have said that, and have said, come back tomorrow with your 3 best charges. I'll let you have 3, and they better not duplicate one another. So this really did surprise me. Why is it?
Well, I think it's posturing. I think it's public posturing by politicians when you get right down to it. In a case they know the country is watching. Now, if I put on my law professor hat, without boring you to tears, I hope, I can explain why legally the prosecutors in Minnesota were permitted to bring 3 different homicide charges for the same death. Okay? I can explain that. And they were. As a strictly legal matter, it was permissible. It was not double jeopardy because each of those 3 different homicide charges required the prosecution to prove at least one essential fact that the other 2 charges did not require the prosecution to prove. So they were not the same offense for constitutional purposes, even though it was the same man Chauvin killed. And again, I mentioned before, our federal system, because of this rule in the U.S. Supreme Court, each sovereign gets 1 kick. Each sovereign gets its own shot, so the federal prosecution was not barred by double jeopardy. That's legal doctrine, okay? Let me start with what I think was the most defensible decision that the federal and state prosecutors made, and the least subject to any fair criticism as posturing. I do not begrudge the federal prosecutors bringing that 2017 charge on behalf of the 14-year-old boy. That was an injustice unrectified. And it was time, in my view, to rectify that, at least that one, okay? I don't begrudge them that at all. But beyond that, when I say posturing, look, the second-degree murder charge, which was the most serious Minnesota state charge against Chauvin, carried up to 40 years in prison. The next most serious charge was third-degree murder. That carried up to 25 years in prison. Second-degree manslaughter, the third of the homicide offenses, was the least serious measured by its maximum sentence, which was 10 years in prison. In the end, this man got 22 and a half years in prison, and that was an upward departure from the otherwise applicable sentencing guidelines that Judge Cahill faced there in Minneapolis. That is to say, he got the same sentence he could have gotten on either of the two most serious charges. Okay? And then along come the feds. Once any money he had to defend himself is exhausted and he's been packed off to state prison, now come the feds. Little surprise, he's played out. He pleads guilty to the federal charges. And the agreement there was concurrent time. So yes, he got 21 years under federal law, but running concurrently at the same time with the 22 and a half years he got under Minnesota law. And it allowed him to serve his time in a federal prison rather than in a state prison. Now, many, not all, but many people facing prison time would choose a federal prison, depending on what security level they expect to be at, but many would choose a federal prison. I don't know how Derek Chauvin felt about that. I don't care. But often federal prison is a desirable or at least undesirable choice if you're facing prison time, and he got to serve his time there. In doing his time, even though the federal sentence sounds shorter, that actually is the one that will govern, because he's got to do about 85% of that 21 years. He only has to do 2/3 of the 22 and a half years that the state court imposed. And again, they're running at the same time. So the federal sentence will become the governing sentence. Now, in a cruel twist of fate, you may know that Chauvin was attacked by another inmate in federal prison in early December 2023. He was stabbed 22 times with a shank, with an improvised knife or edged weapon. He survived, and he's since been moved to a lower security federal prison where the population of other inmates may not be as dangerous. But I do think, to tie this up, Jonathan, effectively the state prosecutors felt pressure to throw the book, as you said, and this gave them effectively 3 chances to win the case. Now, they won all 3 counts, and he did no extra time. So it all was a bit of public display or posturing, in my view, with the exception of some accountability for what he did to that 14-year-old child back in 2017.
Of course, the other interesting subject that comes out of what you've just told us, Dean, is actual sentencing in the 2 jurisdictions on opposite sides of the pond. Because if I were to take a guess of what Chauvin would have got after a contested trial, it would have been a manslaughter conviction, because nobody said he intended to kill the guy. I would guess he would have got 10 years, maximum 12. But in England, that meant 50% jail time served and then out on license. And actually, things are so overcrowded in the British prisons now that they're finding any excuse to let them out after serving 1/3 of the sentence, and then they give them various conditions. They've got to behave themselves or they can be brought back. So the reality is that your system makes Mr. Chauvin serve, on my very rough maths, about 18 years. Whereas if he'd done the same thing in Britain, I think he would actually be serving, if he'd done it today at least, about 4 or 5 years maximum.
Well, and it gets even more interesting than that. I agree. That's fascinating. And the United States of America, the fact is, has some of the longest prison sentences in the world. We do have the longest average sentence certainly in the developed world. But what's especially interesting about that, Jonathan, is that Minnesota is among the least punitive of the American states. Consider this, okay? Original sentencing guidelines in Minnesota on this would have been 12 and a half years. I mentioned the judge upward departed, as he was allowed to do, and was almost sure to do under these circumstances, including the public glare. But the basic sentencing guideline in Minnesota for this would have been 12 and a half years, not too different than you described in England. Now, he would have done 2/3 of that time, at least theoretically, not a half, but not so very different. The next state over to the east, my state, Wisconsin, adjoining Minnesota, okay, his sentence would have been much harsher in Wisconsin. And indeed, if you look at these two states, their demographics are nearly identical, okay? Racial, ethnic, socioeconomic demographics, almost identical. And their populations are very nearly identical. Wisconsin, 5.9 million, Minnesota, about 5.7, or a little over 5.7 million. Wisconsin has 19 prisons and something like 20,000 prisoners. Minnesota has 10 prisons and 8,000 prisoners. Let that sink in. So really, Chauvin happened to live in and be prosecuted in among the least punitive U.S. jurisdictions, is the reality. And yet you still wind up with a sentence. And I'm not suggesting it's not justified. Were I George Floyd's family members, I would be saying Chauvin got off pretty easily. I understand that. But compared to the rest of the United States, his sentence was shorter than you would have expected in many U.S. jurisdictions. And to close out your point, you said this would have been manslaughter in the United Kingdom. Each one of these three crimes, each with a different name, second-degree murder, third-degree murder, second-degree manslaughter, each of them functionally is a version of manslaughter under English law.
Just seems an incredible overcomplication.
Well, welcome to the United States.
And it also seems to me, and I hadn't really appreciated this sufficiently, although, heavens, I know more about America, I think, than the average Brit. If you're going to be a professional criminal in America, you need to research your states. You need to research where it's best to do it.
Well, there's 27 with the death penalty and 23 that don't have the death penalty, if you're really minded to be a terrible criminal. And then, yes, there are enormous variations, and this is part of what makes a federalist system and one with 50 states such a rich, complicated, fascinating place.
Funny country you've got there, Dean. Can I move to another topic which emerges from this fascinating case? Now, of course, Chauvin did not give evidence in his own defense. As best I can judge, and I'd like you to tell me if I'm right, most American criminal defendants seem not to give evidence in their own defense. They seem to be advised, as it were, as the default position, do not go into that witness box. Now, in Britain, it's quite the opposite. The default position is you must call your client, because if you don't, you pretty much expect to be convicted. And particularly in a case like this, it seems to me if I'd been defending him in Britain, you would want to call him to say, I didn't intend to kill him. I'm sorry. I'm terribly remorseful. I didn't realize the passage of time. He was struggling. He was being non-compliant, all that sort of thing. You'd want to hear from Chauvin himself as to why that knee stayed on the neck all that length of time. How could you defend him properly without calling him? And why is it that the position in the States, the default position, seems always to be you don't call them?
Let's start there. You mentioned before that when Tony Blair occupied 10 Downing Street, the law in England was changed. Centuries of law was changed so that if the accused in a criminal trial chose not to give evidence on his own behalf, the jury was invited and is invited today to draw an adverse inference. That is, to draw an inference of possible guilt simply from the silence of the accused. That's a change that U.S. law has not made. We still have an absolute privilege against self-incrimination, and the jury is told, if the accused elects not to testify, the jury is told, you may not draw any inference from the defendant's decision not to take the stand and testify. Now, is that spitting in the wind? Is that, whistling a happy tune past the graveyard? It might be, because I think most jurors probably say, gee, if it were me and I were innocent, I'd get up and say so. Okay? But the jury is at least instructed by the judge in the United States, if the accused elects not to testify, that no inference can be drawn from that. It can't be considered. All right? You say it's the rule in the U.S. that the accused, the defendant, does not testify. I think it's more complicated than that. I suspect that you're right that in a majority of cases, the defendant does not testify. But let's put that in context. There's a substantial minority of criminal cases that are tried in which the defendant in the U.S. does testify in his own behalf. And among my fellow defense lawyers, I know some who say, if you go to trial, your client always should testify. I know others who firmly believe if you go to trial, your client should not testify. But there's a split there, and it's not as rare as you might think for the accused to testify in the U.S. Also, bear in mind in the U.S. that the jury trial, is the rare exception in and of itself. 95% plus of criminal cases in the U.S. get resolved with a guilty plea, in which the defendant does admit guilt and offer whatever mitigation he can.
That, by the way, is the same in Britain, that the vast majority of cases end in guilty pleas. But I don't want to interrupt you. This is fascinating.
No, not at all. I'm glad you did. And I think probably when you started practicing law, that picture in Britain was very different. I suspect a higher percentage of cases went to jury trial when you began practice than do now. And I don't know to what extent in Great Britain you've moved toward the American system of actual plea bargaining.
Hardly at all. Surprisingly enough, plea bargaining has a dirty name in Britain. Even today, it's the love that dare not speak its name. It hardly happens.
And it happens all the time in the U.S. And indeed, in another sharp difference between our two countries, in the U.S., the prosecution's sentencing recommendation carries great weight with almost every judge who sentences. Great weight, sometimes just flat out determinative weight. I think, as I understand it in Great Britain, correct me if I'm wrong, the advocates have almost nothing to say about sentence. That's a matter left entirely to the judge's discretion, as I understand.
Well, you're almost right. The prosecution advocate is not allowed to say anything. He's only allowed to refer the judge to the guidelines that exist. We have what's called a sentencing guidelines council, and the judges on that, as you have indeed, sentencing guidelines, they publish their suggestions, their starting points, the range and all the rest of it, aggravating features. And all the prosecution advocate can do is to refer the judge to those, literally no more. The defense, of course, say far more. And yet there's still a convention, which I've never understood, that the defense never actually say we're asking for the figure of 7 years or 10 years or 12 years. God forbid. They hedge it round like it's a debating society in Oxford or Cambridge. Please be lenient for this reason and don't be too excessive for that reason. And I remember once going to Malaysia to do a case many years ago, and I saw the advocates there weren't frightened to say they considered the guidelines which they had and all the rest of it. Therefore, we submit this sentence should not be longer than 8 years. And that seemed to me such good common sense. I don't know why, I did it once in Britain. I thought I'm going to be brave. Having come back from Malaysia, the judge was very displeased with me. So I was sorry I did it, and I haven't done it since. Now, of course, as you know, I'm as old as Father Time, so I practiced for best part of 25 or 30 years before Tony Blair's reforms. And I can tell you that even then, when our judges also had to direct juries that they must draw no adverse inferences whatever from the fact the defendant failed to testify because that was his absolute right. And despite that, we all knew, we defending barristers, in reality, you should call them. And if you don't, you've got a lot of explaining to do to the jury.
Here, I would have advised, had I been representing Derek Chauvin, I would have advised him not to testify. And if I'd been Derek Chauvin, I probably wouldn't have testified as, the person in the defendant's seat. Why? Because none of these 3 homicide charges even alleged that he intended to kill George Floyd. All of them were unintentional. And the whole thing was on body-worn cameras and, of course, the teenager's video. So it was there to be watched in its details, and Chauvin would have the opportunity at sentencing, which was a nearly foregone conclusion, I think, under all the circumstances. He would have the opportunity at sentencing to say anything mitigating in his own behalf. He also faced a risk at his state trial that he would not have faced in Great Britain, and I would end with this. Had he testified in the state trial, what he said could have been used against him in the federal trial that would follow. Now, that federal trial never happened. It was resolved with a plea agreement. But he didn't know that at the time he stood trial in state court. He was facing life in prison under federal law. That deprivation of civil rights charge actually carried the longest possible sentence. It carried a life sentence up to life under federal law. So he was stuck. If he testifies in the state trial, anything he says now can be used by the prosecution in the ensuing federal trial.
Interesting, because if I had been defending Chauvin in Britain, and boy would I have loved to have done that because I love defending the underdog, I would definitely have called him, and I would have prepared him well so that we would be bringing out what a fine police officer he'd been, what a dedicated police officer, how all these allegations of previous stuff were malicious, how he'd been presented with impossible circumstances on the day, a hostile crowd, a hostile person he was trying to arrest, etc., how mortified he was, how his own life has been totally ruined, and particularly if he'd been at all likable, I'd have wanted to bring that out. And equally, if he'd been just plain stupid, I'd have wanted to bring that out, because that could explain this 9 minute and 29 seconds if he'd just been concentrating perhaps on the crowd rather than the man under him, all that sort of thing. But I would have known instinctively that in Britain he'd have had a better chance of acquittal. And I think I'd have, even if we'd had the federal trial in the wings, I think I'd have still taken the risk, because I couldn't imagine that anything he would be saying could prejudice him at the federal trial, and I'd have made sure it didn't, if you see what I mean.
Well, I do. I think had you pursued that here, you would have opened the door to the prosecution on cross-examination, questioning him about each of those 18 prior civil complaints and all their details and what he had done in all of those, as to his dedicated good faith as a police officer. And you'd have been answering a charge that wasn't laid, which is saying I didn't intend to kill somebody, I don't think gets you very far when nobody's alleging that you intended to kill George Floyd, rather that you did so recklessly or negligently or in the course of committing another felony, a battery against George Floyd. So this may be one of these just inescapable differences in the two systems.
Do we not have this in common, Dean, that if you can get your jury to like the defendant, to see that there's a side to him that they hadn't appreciated till then, that he's human too, that he has suffered as well, your chances of acquittal, I can't prove this scientifically, but they always seem to me to go up 50%. And for them to like the guy rather than for him just to be an impersonal figure, I think you've got to call him.
I don't disagree with you on that. And you and I don't know if he's likable. We don't know how he would have projected. That's always one concern, is even clients we like may be very poor public speakers or terrified or come across as cold to a jury. We just don't know. We don't know what the human dynamics were there. Could you have gotten the jury to acquit on a more serious charge and convict only on, say the secondary manslaughter? Maybe, if they really liked him. But the problem you're running there is you're running headlong into all of that pretrial publicity and the inescapable video evidence and setting yourself up for the prosecutor to say in closing, oh, are we to believe that Derek Chauvin is the true victim here? Is that what we're to believe? That Derek Chauvin is the victim, not George Floyd? And that, I think, would have been a devastating argument by the prosecution.
Well, we'll never know, but I'm sure we'll agree on this. There's no such thing as a hopeless case, only hopeless counsel.
Agreed.
The Chauvin case forced the world to confront power, policing, and accountability. Next week, we leave the courtroom behind us and step into royal controversy with Prince Harry. Privilege, rebellion, and a family feud played out on the world stage. But for now, I rest my case.